this part will be, I think this chapter will be familiar with you, but if you live in America, in US, permanently, you must know this concept and terminology and doctrine of this U.S. administrative law. In this chapter, we will deal with the following topics. Number one, the purpose of the administrative law. Number two, primary functions of an administrative agency. Number three, we will discuss the several administrative agencies that regulate the business. Number four, we will discuss the primary source of administrative law that provide the authority and set limits for the administrative agents, because the administrative agent has a strong power and broad power. Therefore, the Congress and government need to limit these agents' strong power. Number five, we will discuss how the Administrative Procedure Act and the Enabling Act of 1933, how these two statutes interrelated with each other in order to provide the agency, administrative agents, with its jurisdictions and the scope of the power. Number six, I will explain the step that is used in administrative rule-making procedures. Number seven, administrative agents have the power in the area of licensing, inspection, adjudication. Okay? Agents has a licensing power, inspection power, adjudication power. Number eight, I will describe the limits on agency power that is imposed by the legislative branch of the government and executive branch and a judicial branch of the government. Number nine, I will explain the two types of federal public disclosure statute and how These two types of statute make administrative agencies more accountable, more responsible for the public people. Introduction. This chapter begins with the definition and law of administrative law in the American legal system. And this chapter covers the functions, scope, and limits on power of administrative agencies. There are a variety of administrative agents, such as internal revenue services, defense department, Department of Education, Department of Defense, Treasury Department, CIA, Central Intelligence Agencies, and FBI. There are a lot of type of agencies. Okay? This chapter also examines the ways in which the administrative agents are accountable. So, finally, this chapter covers the law of state administrative law, definition and sources of administrative law. Administrative law is the body of law that is drawn from various sources of law. This body of law define and regulate the federal regulatory agencies, and this law limits the exercise of authority by these agencies. Federal regulatory agents are bodies that functions within a particular executive branch department, such as Internal Revenue Services function within the Department of Treasury. IRS is an agency. Department of Treasury is an agency. Okay, the administrative agencies. An administrative agency serves as a primary means for implementation and enforcement of a statute that is enacted by the federal Congress. Agencies are within the executive branches, but these agents sometimes called as force branches of the federal government because agents has a judicial function such as the hearing and have legislative function such as the rule making and regulation making, and executive functions such as enforcing power, enforcement. Therefore, agents, sometimes called as a force, branches of the government, creating the agencies as society change, as society demands more regulations or demands other governmental actions. Therefore, the additional agencies have been created by the Federal Congress through the enabling legislations or through the Enabling Act of 1933. Legislations state the name of agencies, state the composition of the agents, must state the power of the agencies. Example, Federal Trade Commission may promulgate the rules that have binding legal effect on future behavior and rules that investigate and prosecute the alleged violations and adjudicate dispute regarding the alleged violation of law. Agents, organizations, the organizations of administrative agencies. Agents have many labels. Many labels. The agencies sometimes called as the administration, sometimes called as the agency, sometimes called as an authority, sometimes called as a board, sometimes called as a bureau, commission, department, sometimes called as a division, sometimes called as a services. Therefore, there are a lot of different names of the agencies. The administrative head, the chief of agencies, sometimes called as a chairman, sometimes called as a commissioner, sometimes the chief is sometimes called as a director. Therefore, the chief of administrative agencies have a lot of names, different labels. The agents typically divide into two departments, bureaus, regional offices. Okay, therefore there are a lot of different agency names in the America. Therefore, you do not confuse these different name of agencies. Okay? Administrative agencies. Agency type. There are two big categories of federal administrative agencies. Two types of agencies. Executive agencies, independent agencies. Two types. Executive agencies are created by the U.S. President. The President may appoint the head of executive agencies. President may remove, terminate, fire the head of executive agency at any time with cause or without cause. That is the executive agency. Example of executive agency is Department of Defense, Department of Education. Department of Education regulated all of the college, school, universities. Okay? Department of Defense. Department of Defense consists of Army, Navy, Air Forces. Okay? Department of Treasury. Another type of agencies is independent agencies. Independent agencies are agencies that are existed outside the federal executive department and existed outside the executive office of the U.S. President. Example of independent agencies are CIA, Central Intelligence Agencies, or EPA, Environment Pollution Agency, or IRS, Internal Service Revenue. Okay? These independent agencies are headed by the board or headed by the commission. The chief of commission is referred as a commissioner. Commission members and board members are finally appointed by the president with the advice and consent of the Senate. Congress consists of two types, Senate and Parliament. Okay? Okay, another topic. Agents, procedures. Federal agencies exercise of rule-making power and adjudicative power constrained by the Administrative Procedure Act. Administrative Procedure Act regulates the agencies' exercise of rulemaking power and adjudicatory powers. This agency power to act and procedure to take action are detailed, specified, written in the Enabling Act of 1933. Therefore, Enabling Act of 1933 regulated the agency's power, a lot of power. Primary functions of the administrative agency. Primary functions of agencies. The agencies have wide range of functions that is related to the formation of agencies, implementations of agencies, and enforcement of regulations that is intended to administer the federal law. Okay, policy making functions, agencies, policy making functions. Agencies are charged by the Congress, to study the potential solutions to the problem and to exercise legislative functions. Congress burden, charge the agencies to exercise legislative functions by creating legally enforceable rules known as administrative regulations. That administrative regulations purport to satisfy the Congress objective, Congress goal, Congress will, by means of filing in the details of the statute. This policy-making function is known as rule-making. Okay. Investigating functions and enforcement functions of the agencies. Many administrative agents have one agents enforcement division. This enforcement division will be devoted to investigating the alleged violation of agencies' administrative regulations, or to monitoring compliance with regulatory requirements, and to recommending enforcement actions such as the fines and other sanctions and penalties. That is the type of enforcement actions. Agents' enforcement action include the fines, penalties, and other sanctions. That is the enforcement functions of the agencies. Licensing functions and permitting functions of the agencies. Some agencies are responsible for licensing and permitting in a wide variety of areas. This area includes license for of professionals such as the medical doctor, attorney, CPA, financial analyst, and enrolled agent before ILSs, and license for industries. Example of licensing function includes Security and Exchange Commission, Federal Security and Exchange Commission have a power to issue the license to certain professional individuals who is involved in public training of the common staff, or the Federal Communications Commission have a power to license the television station and radio stations. The agencies also issue the permits such as that issued by the Environment Protection Agency to control the pollutions, to control the air pollutions, to control the air pollution, water pollutions. Okay. Another function is a distribution function. Distribution function of agencies. Okay. Distribution function of federal statutory benefits to the public. Agencies are involved in the application process, are involved benefits, distribute the benefits according to the federal law. Such as Social Security Act. Example: Social Security Administrations, Social Security agencies is responsible for distributing the retirement payment and distributing the medical benefits to the eligible citizens. Whose age is reached 62 years old. Citizens whose age reached 62 years old have a legal right to receive the retirement benefit from those Social Security administrations. The citizens whose age reached 65 years old has a legal right to receive the medical benefits from the Social Security administrations. Therefore, administrative agents have a function to distribute the federal benefits to the eligible citizens. Sources of the administrative law. Administrative law is a combination of several different sources of law. This source of law, different sources of law, includes the U.S. Constitution's Administrative Procedure Act, the Enabling Statute of 1933, and the Common Law. Okay, that is a source of administrative law. According to the source of administrative law, agents have a variety of power. Scope of the administrative agency power. The basic discretionary power agents may have are rulemaking power, investigating power, enforcement power, licensing power, adjudicating power. Okay? These power are the basic discretionary power of agencies. Agencies' formal power also offer the significant informal power. Agency formal power offer another type of informal power in the form of the agency's advices, in the form of the agency's suggestions, in the form of the agency's guideline. This power is an informal power. Okay? This informal power lacks the legal force of formal agencies' regulations. However, this informal power are very, very persuasive in shaping the behavior of regulated industries. Rulemaking power of agencies. Agencies develop rules in order to be used in facilitating the government's administration of the law. This rulemaking power is derived from the Enabling Legislation or Enabling Act of 1933. And this rulemaking power must comply with the Administrative Procedure Act. Rulemaking process is set out in Administrative Procedure Act and is supplemented by enabling statute of 1933. Practically, much of the agency's rulemaking duties are carried out through the informal rulemaking procedures that are permitted under the basic structure of Administrative Procedure Act. Okay, there are, I told you, there are two types of rulemaking power. Informal, formal rulemaking power and informal rulemaking power. Okay? Informal rulemaking power is known as notice and comment rulemaking. Informal rulemaking power is the most common method that is used by the administrative agencies. This informal rulemaking are not enforced, cannot be enforced by enabling legislations to follow more stringent procedures of formal rulemaking. The process of the informal rulemaking includes the publications of notice of a proposed rulemaking in the Federal Register and comment period. Second step is a comment period. First step is a publications of notice of future proposed rulemaking in the Federal Register, in the Federal daily publications. Final step is a publication of regulations in the final form in the Federal Register. Federal Register is a daily federal government's publications that is distributed by the federal government. Is referred as a Federal Register. Daily publications of the federal government is referred as a Federal Register. Okay, second type of rulemaking power is a formal rulemaking power. A formal rulemaking begins with a notice of future proposed rulemaking. Notice of future proposed rulemaking. Then notice will be published in the Federal Register, Federal daily publications. The formal notice must state the time and place at which a public hearing will be held. probably hearing will be held at some time at the place of something. This formal notice must be published in the Federal Register. Okay. Based on agents' findings of the fact, the future proposed rule will be articulated and published in the Federal Register in order to give the notice to those peoples who is affected by this rule. Hearing resembles trials. Is a type of formal rulemaking power. Under the hearings resemble trials, agencies must produce the evidences and agents must justify proposed regulations. The interested party can present the evidences in opposition before the hearings resemble trials, before the judge of hearings resemble trials. Another type of power is investigating power. Agents need the accurate information about the business activities in order to detect and prosecute the violation of law and to identify the areas in which the rules should be added or modified. Agencies' investigations must be authorized by law, such as the Enabling Act of 1933 or Enabling Regulations or Administrative Procedure Act. These agencies' investigations must be conducted only for the legitimated purposes. Two most important investigative tools. There are two types of investigating tools. These two tools include subpoenas. Is the first tool. Search and seizure is the second tool to investigate. Okay, first tool, subpoenas. There are two types of subpoenas. Subpoena at testify quantum and subpoena dues, TICA. Most Most legal terminologies come from the Latin word, Latin terminology. Subpoena, ad testi, conterm, subpoena, deus, tecum, come from the Latin word. Okay, first type of subpoena. A subpoena, ad, testify, conterm, compares unwilling witness, appear. You must mandatory appear before the administrative judge, and you must testify at the hearing. That is the first type of subpoena. Second type of subpoena is a subpoena deus tecum. Subpoena deus tecum compares production of most type of documentary evidence, such as accounting, record, office, memorandum, financial statement, journal entry, contract, must be submitted under the subpoena deus tecum. Administrative subpoena does not require probable cause, but are intrusive and constitutional protection apply, especially the Fourth Amendment of U.S. Constitution protect the unreasonable such as items. Okay, limitations on subpoena. Information sought must be relevant to their purposes, and information must not be privileged, and information demands must be sufficient, specific, detailed written, and not unreasonably burdensome, and investigation must not compromise important government operations that is conducted by another unit of the government. Okay, second type of subpoena is second type is a such. Second type of tool for investigating power is a search and seizure. The policeman, the detective, can search the individual belongs and seize the individual asset at any time based on the probable causes. The agents may seek to gather information by entering into the private property, such as the home, individual residential home, and entry into the private office and entry into the private factory in order to gather information. That is the search and seizure. However, the Fourth Amendment of U.S. Constitution prohibits unreasonable search, unreasonable seizure, prohibit unreasonable seizure. And First Amendment require a warrant issued by the judge based on probable cause. Enforcement power or licensing power and inspection power of the agencies. U.S. Supreme Court has ruled that the agencies have a broad discretion in when and whom to regulate. The agencies also regulate and administer the laws through the licensing tool. Some agencies also monitor the compliance with administrative regulations by conducting the inspection of the business and inspection of individuals within their jurisdictions. Adjudication. Adjudicatory power. Agencies have the power, authority to adjudicate the matters under their jurisdictions by holding a hearing between the government and private individuals in front of an administrative law judge. In most agencies, the presiding officer is an administrative law judge. This administrative law judge is an attorney who is employed by the agents in order to adjudicate the dispute between the two parties. Agents has a power to conduct the judicial proceedings in order to determine whether or not a statute or regulation has been violated. Generally, the process of adjudications begins with the complaint filed by the agents. Agents file the complaint to the agent's court, and the respondent, the party charged in the complaint, must file an answer, respond the answers. In the hearing before the judges, the testimony and evidence are allowed, but no jury is present. Because the administrative agent is not the legislative branches. Administrative law judge renders provide the decision with a finding of fact, not finding of judge. Finding of fact belongs to administrative law judge, and administrative law judge renders the conclusion of law and appropriated penalty if necessary. administrative law judge's decision may be appealed for de novo review by governing body of agencies. De novo review means a new trial, Latin word. De novo means a new. Review means a trial, new trial. In a de novo review, governing body may reject or adopt the administrative law judge's finding of fact. Most agents' proceedings settled by consent order before completing adjudication processes. Appeals. Losing party in an American law judge cases generally have an automatic appeal to the administrative head of the agencies, who may overturn or affirm or accept administrative law judges. Limits on administrative agencies. Okay. There are three branches: legislative branches, executive branches, and judicial branches. All branches have various means of power that limits, that restrict the power of administrative agencies. First, remit is presidential control of the agencies. The chief of executive branch is president, U.S. president. The executive branch may shape agency action through the U.S. president's power to appoint the chief, to remove, to terminate, to fire the agents, administrators. Okay? And through the president's power to veto resolutions that is related to administrative agencies, and through the influences of the executive budget, money. Second time is congressional control of the agencies. Congress may shape agency action through its advice and consent laws in agency appointments, and through its power to amend agencies, enabling legislations, and through the power to pass the legislation that mandate change in agency practice and agency procedures. Example: National Environmental Policy Act require the agencies to file the environment impact statement for every major federal actions that may impact the environment. Okay, so type of control is a judicial review, judiciary control, judicial review of the agencies. The courts exercise greatest control over agencies' behavior because the Administrative Procedure Act allows the judicial review of most agent actions. If federal court finds that agents violate the judiciary authority, in that cases, agency actions will be cancelled. Agencies, regulations will be void. Individual persons or individual organizations who is fitting the judicial review must demonstrate the following elements. 4 elements. My agent's action. The first elements demonstrate that agency's action being challenged is reviewable. Challenging party has standing to sue. Standing is a legal terminology. Standing means the status or position. I have a status, legal status, to sue against a third party. That is the meaning of standing to sue. And all required administrative remedies have been exhausted. I have no choice except file a lawsuit against the defendant. Okay? Last element is the dispute or controversies is live for a judicial review. My controversies against the third party always live for the final judicial review. That is the elements of the judicial review. Okay, first element, standing to sue. An individual person and organizations must prove they have standing to seek judicial review of an agent's action. They have stated they have a legal right to seek judicial review, or they are the aggrieved party. Aggrieved party means them is the party. Therefore, I am a plaintiff status. Therefore, I have a legal right to sue against the dependent party. Okay? First, and to sue, they have suffered the injury, suffered the damage to the interest that lies within the general interest that is protected by statute and constitutional provisions serving as a basis of challenges. Judicial deferences. If a question of fact and question of policy is at issue in the case challenging agency actions, the court, the judge generally defer to agency's decisions. Defer means to adopt, allow, permit. The judge adopt agencies, administrative agencies' decisions. However, the judge least likely to defer to agency action when questions of law are at issue. Okay? The judge generally defer to agency action when finding of fact are at issue. In that case, the judge adopted the agency decisions. However, the law, question of law are at issue. The judge does not adopt the agency's action because finding a law is a judge's job. Information control. There are three statutes that regulate the flow of information. That information is held by the agents or gathered by the agencies. First statute is the Freedom of Information Act. Freedom of Information Act works enacted to enable the private citizens to obtain access to documents in government's positions. I want some people's tax return under the Freedom of Information Act. In that case, if judge approve, the IRS agents must submit that information to the plaintiff. Okay? Under the Freedom of Information Act, the agency bears the burden of justifying denial, and deniers are appealable to Federal District Court. And agents sometimes exempt certain documents from disclosure if judge allow. Second type of act is Government in the Sunshine Act. Government in the Sunshine Act requires that agents must announce their meetings at least 1 week in advance and open a meeting to the public. That is a Government in the Sunshine Act. Okay. Administrative law at the state level. State frequently have agencies. Several types of state agencies. That agencies are devoted to regulations of parties within the state borders, such as for the state of securities. State security law is referred as a blue sky laws and protection of the environment within the border of the state and regulation of bank and insurance company within the state and workplace safety regulations within the state and consumer protection within the state and labor and employee anti-discrimination regulations within the state. Okay, I finished the chapter and we have about 10 minutes. Careful. Quick catch up for this chapter. First, times 2 part questions. Agencies, the administrative agencies are created by the federal Congress through the enabling regulations or through the enabling Act of 1933. True. The Federal Procedural Act constrains agencies. False. An agent's subpoena may request information that is privileged as long as it is necessary to the investigation purpose. Informal rulemaking is also known as notice and comment rulemaking. True. Under the Freedom of Information Act, the plaintiff bears the burden of proving the denial was wrongful. False. Agency bears the burden of proof. If an agent's decision is challenged, the the judge generally defer to the agent's decision. True. Okay? Normally, the judge generally adopt the agency's decisions. Multiple choices. The basic discretionary power agents may have are A. Rule-making power, B. Investigating power, C. Adjudicatory power, D. All of the above. Correct answer is D. Agents has rule-making power, investigating power, adjudicatory power. Okay. Which of the following is not a legal basis for challenging the agent's action? A. Ultra bias doctrine. Correct. Agents fail to obtain advice and consent. False. C. Agent's action was unconstitutional. D. Agents failed to comply with the Administrative Procedure Act. E. None of the above. B is the correct answer. Okay. B is not a legal basis for challenging the agency's actions. Okay. Last slide. An individual or organizations who is a victim the review of an agent's action must show A. Must show